Hello and welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content every morning at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and ring that notification bell so you can be updated every time we upload new content. Let's get started. Question number 1. In which of the following situations is the defendant most likely to be convicted, even though he did not intend to bring about the harm that the statute defining the offense is designed to prevent? A. Defendant was the president of an aspirin manufacturing company. A federal inspector discovered that a large number of aspirin tablets randomly scattered through several bottles in a carton ready for shipment were laced with arsenic. Defendant is charged with attempted introduction of adulterated drugs into interstate commerce. B. Defendant struck victim in the face with a baseball bat, intending to inflict a serious injury. Victim died and after being hospitalized for 3 days. Defendant is charged with murder. C. Defendant burglarized a jewelry store, intending to steal some diamonds. As he entered the store, he short-circuited the store's burglar alarm system, thereby preventing a warning of his entry to the police. The smoldering wires eventually caused a fire that destroyed the store. Defendant is charged with arson. D. Defendant wanted to frighten victim's friend by placing a plastic rattlesnake in their lunchbox. When victim mistakenly took the lunchbox and opened it, believing it to be his own, the plastic rattlesnake popped out. As a result of the fright, victim suffered a heart attack and died. Defendant is charged with manslaughter. Take 10 seconds. Choose the best answer. If you chose B, you'd be correct. On the bar exam, every murder is second-degree murder unless you're specifically told otherwise. Second-degree murder is the intentional killing of a person with malice and aforethought. Malice aforethought exists if there is no excuse justifying the killing, no adequate provocation can be found, and if the killing is committed with one of the following states of mind. A. Intent to kill. B. Intent to commit great bodily injury. C. Depraved heart killing. Or D. Intent to commit a felony. Here, only B shows a situation where defendant can be convicted for a crime even though he did not intend to bring about the harm that the statute defining the offense is designed to prevent. Defendant did not intend to kill victim. When defendant struck victim in the face with a baseball bat, however, defendant's intent to seriously injure victim with a baseball bat is sufficient to meet the great bodily injury element for murder. As such, B is the situation where a defendant is most likely to be convicted of murder, even though he did not intend to kill the victim. Question number 2. Dove is on trial for theft. At trial, the prosecutor called John and Mei Wang. They testified that as they looked out their apartment window, they saw thieves across the street break the window of a jewelry store, take jewelry, and leave in a car. Miss Wang telephoned the police and relayed to them the license number of the thieves' car as Mr. Wang looked out the window with binoculars and read it to her. Neither of them has any present memory of the number. The prosecutor offers as evidence a properly authenticated police tape recording of Mei Wang's telephone call with her voice giving the license number, which is independently shown to belong to Dove's car. A tape recording of Mei Wang's statement stating the license number is A. Admissible under the hearsay exception for present sense impression. B. Admissible as non-hearsay circumstantial evidence. C. Inadmissible because it is hearsay not within any exception. Or D. Inadmissible because Mrs. Wang never had first-hand knowledge of the license number. Take 10 seconds. Choose what you believe to be the best answer. If you chose option A, you'd be correct. Admissible under the hearsay exception of present sense impressions. Hearsay is an out-of-court statement being offered to prove the truth of the matter asserted in that statement. Hearsay is generally inadmissible. Hearsay included within hearsay is not excluded under the hearsay rule if each part of the combined statements conforms with an exception to the hearsay rule provided by the federal rules of evidence. One exception to hearsay is the present sense impression exception. A hearsay statement is admissible if it is describing or explaining an event or condition made while the declarant was perceiving the event or immediately thereafter. Excitement is not required. In this case, there are two levels of hearsay. First, the police tape recording of May's statement to the police operator is being offered to prove the truth of the matter asserted in that statement, i.e., thief's license plate number was the one given by her. May's statement was a present sense impression of John's statement, as John was reading the license plate number to her, so it qualifies as a hearsay exception. Secondly, John's statement to May is being offered to prove the truth of the matter asserted in that statement, i.e., that the thief's license plate was, in fact, what he read out it to be. John's statement was also a present sense impression because he was reading off the license number as he was seeing it through binoculars, so it qualifies as a hearsay exception. Therefore, the tape recording is admissible under the hearsay exception for present sense impression. Question number 3. Oliver, owner of Blackacre, needed money. Blackacre was fairly worth $100,000, so Oliver tried to borrow $60,000 from Len on the security of Blackacre. Len agreed, but only if Oliver would convey Blackacre to Len outright by warranty deed, with Len agreeing orally to reconvey to Oliver once the loan was paid according to its terms. Oliver agreed, conveyed Blackacre to Len by warranty deed, and Len paid Oliver $60,000 cash. Len promptly and properly recorded Oliver's deed. Now Oliver has defaulted on repayment with $55,000 still due on the loan. Oliver is still in possession. Which of the following best states the parties' rights in Blackacre? A. Len's oral agreement to reconvey is invalid under the statute of fraud, so Len owns Blackacre outright. B. Oliver, having defaulted, has no further rights in Blackacre, so Len may obtain summary eviction. C. The attempted security arrangement is a creature unknown to the law, hence a nullity. Len has only a personal right to $55,000 from Oliver. And D. Len may bring whatever foreclosure proceeding is appropriate under the laws of that jurisdiction. Take 10 seconds and choose what you believe to be the best answer. If you chose option D, you'd be correct. An equitable mortgage is where the owner of an estate transfers the title deed to a person from whom he has borrowed money, either with an accompanying agreement to execute a regular mortgage or without even any verbal agreement respecting a regular mortgage. An equitable mortgage is treated just like a regular mortgage. In this case, the agreement between Oliver and Len is clearly an equitable mortgage, so Len may bring whatever foreclosure proceeding is appropriate under the laws of the jurisdiction to terminate Oliver's interest in Blackacre. Question number 4. When Prudence was leaving an elevator, it suddenly dropped several inches, causing her to fall. An investigation of the accident revealed that the elevator dropped because it had been negligently maintained by the Acme Elevator Company. Acme had a contract with the owner of the building to inspect and maintain the elevator. Prudence's fall severely aggravated a pre-existing physical condition. If Prudence sues Acme Elevator Company for damages for her injuries, she should recover A. Nothing, if Acme could not reasonably have been expected to foresee the extent of the harm that Prudence suffered as a result of the accident. B. Nothing, if the accident would not have caused significant harm to an ordinary prudent elevator passenger. C. Damages for the full amount of her disability because a tortfeasor must take its victim as it finds them. Or D. Damages for the injury caused by the falling elevator, including the aggravation of her pre-existing condition. Take 10 seconds. I hope you chose option D because you'd be correct. To establish a prima facie case of negligence, the plaintiff must show a duty, a breach of that duty, causation, and damages. When a foreseeable plaintiff suffers an unforeseeable extent of harm, the defendant takes her plaintiff as she finds her. If you remember, this is the eggshell doctrine. So the defendant will be liable for all injuries resulting from her negligence. Here, Prudence had a pre-existing physical disability when the elevator dropped several inches, causing her to fall and severely aggravate her pre-existing physical disability. Even if the extent of harm Prudence suffered was unforeseeable due to her pre-existing physical disability, Acme Elevator Company must take Prudence as she was. So Acme Elevator Company will be liable for all injuries resulting from its negligence. Therefore, Prudence should recover damages for the injury caused by the falling elevator, including the aggravation of her pre-existing disability. Question number 5. Eddie worked as a cashier in a restaurant. One night after the restaurant closed, Eddie discovered that the amount of cash in the cash register did not match the cash register receipt tapes. He took the cash and the tapes, put them in a bag, gave them to Rita, the manager of the restaurant, and reported the discrepancy. Rita immediately accused him of taking money from the register and threatened to fire him if he did not make up the difference. Rita placed the bag in the office safe. Angered by what he considered to be an unjust accusation, Eddie waited until Rita left the room and then reached into the still open safe, took the bag containing the cash, and left. Eddie is guilty of A. Larceny, B. Embezzlement, C. Either larceny or embezzlement, but not both, or D. Neither larceny nor embezzlement. Take 10 seconds. If you chose option A, larceny, you'd be correct. Larceny is the wrongful taking and carrying away of another's tangible personal property without consent and with the intent to permanently deprive. Embezzlement is the fraudulent conversion of another's personal property by a person in lawful possession. In this case, Eddie wrongfully took the bag containing the restaurant's cash out of the safe and left. Eddie is guilty of larceny. Eddie, however, was not in lawful possession of the bag at the time he took it out of the safe, so Eddie is not guilty of embezzlement. Thus, Eddie is only guilty of larceny. Question number 6. Troff, the manager of a state fair, contracted with Schweinbach, a renowned hog breeder, to exhibit Schweinbach's world champion animal, Mega Hog, for the 3 weeks of the annual fair, at the conclusion of which Schweinbach would receive an honorarium of $300. 2 days before the opening of the fair, Megahawk took sick with bursitis, a communicable disease among swine, and under the applicable state quarantine law, very probably could not be exhibited for at least a month. Upon learning this, Troff can legally pursue which of the following courses of action with respect to his contract with Schweinbach? A. Suspend his own performance, demand assurances from Schweinbach, and treat a failure by Schweinbach to give them as an actionable repudiation. B. Suspend his own performance and recover damages from Schweinbach for breach of contract unless Schweinbach at once supplies an undiseased hog of exhibition quality as a substitute for Megahog. C. Terminate his own performance and treat Megahog's illness as discharging all remaining duties under the contract. Or D. Terminate the contract, but only if he seeks promptly to obtain for the exhibit a suitable substitute for Megahog from another hog owner. Take 10 seconds. Choose the best answer now. If you chose option C, you'd be correct. Terminate his own performance and treat Megahog's illness as discharging all remaining duties under the contract. Performance can be excused by later unforeseen events, such as something unexpected taking place after contract formation but before performance. Impossibility, however, occurs when A. Circumstances affecting the contract have changed. B. The contract is not due to any act by the defendant. And C. The change in circumstances causes performance to be impossible for the defendant. Objective impossibility excuses performance, while the general rule is that death or physical incapacity of a party to a contract after contract formation, but before performance, does not excuse performance. The death or physical incapacity of a person necessary to effectuate the contract will excuse performance. Here, Troff had contracted with Schweinbach for Megahog to be exhibited at an annual state fair for the fair's duration of 3 weeks. Megahog was not just a normal hog, but a world champion animal. When Megahog got sick and very probably could not be exhibited for at least a month, which meant Megahog would miss the annual fair in its entirety, performance under the contract likely became impossible. Megahog was specifically named in the contract, and when that particular world champion animal was incapacitated for the fair's duration, Troff's performance likely became excused. As such, Troff can terminate his own performance and treat Megahog's illness as discharging all remaining duties under that contract. Question number 7. Big City High School has had a very high rate of pregnancy among its students. In order to assist students who keep their babies to complete high school, Big City High School has established an infant daycare center for children of its students and also offers classes in childcare. Because the childcare classes are always overcrowded, the school limits admission to these classes solely to Big City High School students who are the mothers of babies in the infant daycare center. Joe, a student at Big City High School, has legal custody of his infant son. The school provides care for his son in its infant daycare center, but will not allow Joe to enroll in the child care classes. He brings suit against the school, challenging, on constitutional grounds, his exclusion from the child care classes. Which of the following best states the burden of persuasion in this case? A. Joe must demonstrate that the admission requirement is not rationally related to a legitimate governmental interest. B. Joe must demonstrate that the admission requirement is not as narrowly drawn as possible to achieve a substantial governmental interest. C. The school must demonstrate that the admission policy is the least restrictive means by which to achieve a compelling governmental interest. Or D. The school must demonstrate that the admission policy is substantially related to an important governmental interest. Take 10 seconds and choose the best answer now. If you chose option D would be correct. The school must demonstrate that the admission policy is substantially related to an important governmental interest. Equal protection requires that gender-based classifications be substantially related to an important governmental purpose, and there must be an exceedingly persuasive justification. In this case, Big City High School limits admission to its child care classes solely to Big City High School students who are the mothers of babies in the infant daycare center, also established by Big City High School. This admissions policy clearly draws a distinction among Big City High School's students based on gender. Joe, a male student at Big City High School, who has legal custody of his infant son, tried to enroll in the child care classes but was denied because he is not a mother. Since this is a gender-based classification, the school must demonstrate that the admissions policy is substantially related to an important governmental interest. Question number 8. Pike sued Day City Community Church for damages he suffered when Pike crashed his motorcycle in an attempt to avoid a cow that had escaped from its corral. The cow and corral belonged to a farm that had recently been left by will to the church. At trial, Pike seeks to ask defendant's witnesses, Winters, whether she is a member of that church. The question is, A, improper because evidence of a witness's religious beliefs is not admissible to impeach credibility. B, improper because it violates First Amendment and privacy rights. C, proper for the purpose of ascertaining partiality or bias. Or D, proper for the purpose of showing capacity to appreciate the nature and obligation of an oath. Take 10 seconds and answer now. I hope you guessed C, proper for the purpose of ascertaining partiality or bias, because under the federal rules, the credibility of a witness may be attacked by any party, including the party calling that witness. A witness may be impeached by evidence of bias, interest, or motive on cross-examination, or by extrinsic evidence. In this case, if Winters is a member of Day City Community Church, then her testimony as a witness for that church may be biased. Winters can be impeached on cross-examination by evidence of this bias. Therefore, the question is proper for the purpose of ascertaining partiality or bias. Question number 9. Oscar, owner of Greenacre, conveyed Greenacre by quitclaim deed as a gift to Anne, who did not then record her deed. Later, Oscar conveyed Greenacre by warranty deed to Belle, who paid valuable consideration, knew nothing of Anne's claim, and promptly and properly recorded. Next, Anne recorded her deed. Then Belle conveyed Greenacre by quitclaim deed to her son Cal as a gift. When the possible conflict with Anne was discovered, Cal recorded his deed. Greenacre, at all relevant times, has been vacant, unoccupied. The Recording Act of the jurisdiction provides no unrecorded conveyance or mortgage of real property shall be good against subsequent purchasers for value without notice, who shall first record. No other statute is applicable. Cal has sued Anne to establish who owns Greenacre. The court will hold for A. Cal, because Anne was a donee; B. Cal, because Belle's purchase cut off Anne's rights; C. Anne, because she recorded before Cal; or D. Anne, because Cal was a subsequent donee. Take 10 seconds. I hope you chose B, Cal, because Belle's purchase cut off Anne's rights. The recording system only protects bona fide purchasers and mortgagees. A bona fide purchaser is a subsequent purchaser for value without notice at the time of conveyance. A race notice jurisdiction will protect a bona fide purchaser who records first. Here, Oscar conveyed Greenacre to Belle for valuable consideration after already having conveyed Greenacre to Anne. Belle qualifies as a bona fide purchaser since she was a subsequent purchaser for value with notice at the time of conveyance that Greenacre had already been conveyed to Anne. Because Belle recorded her deed before Anne recorded her deed, Belle is protected under the jurisdiction's Race Notice Recording Act. This means Belle had valid title to Greenacre, and her subsequent conveyance to Cal was also in fact valid. Accordingly, the court should hold for Cal, because Belle's purchase cut off Anne's rights in their entirety. And our final question of this grouping, question number 10. Gardner's backyard, which is landscaped with expensive flowers and shrubs, is adjacent to a golf course. While Driver was playing golf on the course, a thunderstorm suddenly came up. As Driver was returning to the clubhouse in his golf cart, lightning struck a tree on the course, and the tree began to fall in Driver's direction. In order to avoid being hit by the tree, Driver deliberately steered his cart onto Gardner's property, causing substantial damage to Gardner's expensive plantings. In an action by Gardner against Driver to recover damages for the harm to his plantings, Gardner will A. Prevail, because although occasioned by necessity, Driver's entry onto Gardner's property was for Driver's benefit. B. Prevail for nominal damages only, because Driver was privileged to enter Gardner's property. C. Not prevail, because the lightning was an act of God. D. Not prevail, because Driver's entry onto Gardner's property was occasioned by necessity and therefore privileged. Take 10 seconds and choose the best answer. If you chose option A, you're getting the hang of this quite well. A. Prevail, because although occasioned by necessity, Driver's entry onto Gardner's property was for Driver's benefit. Necessity is a defense for all intentional torts against property. Interference with real or personal property in an emergency to prevent injury to oneself or a third party's person or property is valid as a defense if there is no less damaging method to prevent the harm. However, while the defendant must pay actual damages for the injuries caused, the defendant will not be liable for nominal or punitive damages. In this case, Driver can assert necessity as a defense for trespassing onto Gardner's backyard because Driver had to avoid the falling tree in order to prevent injury. However, Driver is obligated to pay actual damages for the injury caused to Gardner's expensive plantings when Driver avoided the tree. Thus, Gardner will prevail because although occasioned by necessity, Driver's entry onto Gardner's property was for Driver's benefit and Driver's benefit alone. As always, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. And to that end, we upload content every day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and ring that notification bell so you can be updated every time we upload new content.